more and more varied in contemporary societies. Family patterns are changing rapidly from joint extended families to nuclear conjugal ones, and from nuclear to live-in relationships. Some emerging trends in family lifestyle are consensual unions, single parent families and teenage marriages, surrogacy arrangements, same sex marriage, intercaste marriage, adoption, and inheritance. This session intends to unfold these contemporary issues related to family structure in Indian society. The objective for the session today is to understand the relative history of personal laws in India, to synthesize the latest and expected future issues and challenges in personal law in India, to explore new remedies and reform in relation to changing structure of family. In order to fulfill our intent, we have an eminent speaker with us today, Dr. Sangita Laha, Associate Professor and Dean Faculty of National Law University, Ranchi. Dr. Sangita Laha has done MA Political Sciences, MBA Marketing, LLB, and LLM Hindu Law from Patna University, PhD Law and Gender Justice from the University of Calcutta. Ma'am currently is pursuing the postdoctoral program, and her topic for research is titled Democratic Decentralization and Women's Participation, a critical study with reference to Panchayati Raj system in India. Ma'am has published book titled Women and Legal Profession in reference to Indian context. She was assistant professor in the West Bengal National Juridical Sciences, Kolkata Chanakya National University, Patna, and has worked in MIT Law School, MIT University, Lucknow as professor and deputy director, where she was guiding PhD scholars apart from teaching PhD, PG, and LLB students. Currently, she is an associate professor law and dean faculty, National Law University, Ranchi, since 2018. She is teaching Family Law 1 and 2 in the undergraduate level and local self-government and administrative law at postgraduate level. She has presented and published several research papers and articles in general of national and international review. To cite a few, titled Judicial Activism in Patent Law in India as Analysis of Cases, Evergreening of Patents, Substance Use and Abuse in India, a Comparative Study with Order Contrast. Published in international journals of art, humanities, and management studies, and many others. Recently, she was invited as a panelist and spoke on sexual harassment in workforces in the 8th National Conference for Women in Police organized by IPS officer in Ranchi and by the United Nations Office from Drugs and Crime, South Asian region for participating on patterns and trends of trafficking in person in state on 2nd April 2019 at Lucknow, Uttar Pradesh. She was also invited as a resource person on women's studies and gender sensitization in the refresher course by UGC MHRD, Ranchi University, Ranchi. We extend our heartiest welcome to you, ma'am. Delighted to have you. And now over to you, ma'am.
Thank you very much, Manisha. It was a uh, long introduction you gave about me, which was also not required. In a short span, there are many topics that has been given today. In personal law, it is not that very easy to discuss all the 44 topics together, 4 walls together. So what I'll do is I will restrict myself in the 2 topics which are very much of contemporary issue. One is on live-in relationship, because that is very much felt in the metropolitan cities of India. A little bit I'll go into the surrogacy if I get some more time, because if we want to discuss from the legal point, it is better we restrict ourselves into 1 or 2 topics so that we have a greater depth about these topics altogether. Now, what do we understand by live-in relationship? In nomenclature, in normal parlance, a live-in relationship, if you do not just go into the purview of law, just by the simple English meaning, it means staying together under the roof, or just staying together. So it is just a woman who does not want to get married, or a man who does not want to get married, but who wants to stay with his girlfriend or with a woman he wants to live into. So live-in relationship, in other words, is a substitution of marriage. Marriage has got its own sanctity. It is own sacrosanct in nature. And for Indians, for we Indians, marriage is not only a bond, but it is also for peace, harmony, for the extension of the family. But this is not the concept in live-in relationship. So both are vice versa. One can say it is just an arrangement where both the parties want to live together, but don't want to go into the marriage. So nowadays, it is taken as an alternative to marriage, especially in the growing cities of Calcutta, Mumbai, Chennai, Delhi. And except that it has been, debated in many of the Supreme Court cases, or it has been given a definition as a domestic relationship in the Domestic Violence Act. As such, we do not have a proper legislation for live-in relationship. So there are many questions that comes in our mind. What is the status of the party then? In marriage, as for personal law is concerned, both get the status of husband and wife. So mutual rights and obligations starts taking place, which again is an absent in live-in relationship. So the question comes, if it is an alternative for marriage, what happens if such a relationship breaks? Do the parties do not want to ask for alimony, for succession from each other? Or what happens to the children from such a relationship? Earlier, children of such a relationship was not at all recognized. So what happens to the property rights? So all these, legal questions starts coming in the mind. So when youngsters go for live-in relationship, they do not think, except that they do not want to be in any bondage of marriage. So currently, we are very much unclear on this subject, on this topic. Though the modern trend of the youngsters, it was not also in our generations also, but generations now, after decade now the line, the concept is, why do we need a marriage? Why not make some sort of arrangement where we live together, and only when after 3 years, 4 years, 5 years, if the parties are compatible, then only they think of marriage. So as such, we are very much unclear. The law is only given a definition that if only it falls under domestic relationship, then only the battered woman can seek for some alimony or seek in the proprietal relationship. But there are a lot of yardsticks, a lot of, points that needs to be covered if we want to put that relationship under domestic relationship. So legalizing this live-in relationship means a new law is required for governing the relationship or such a relation. Why? What happens when the woman is deserted? Such a woman who falls in love or somehow who is trapped into such a relationship and she's misused and then deserted. Now, in reference to this, since we are talking about personal laws, there are two cases that are very important, but they were old cases. But at the same time, we must know about these two cases because these two cases are the landmark cases. One on Bhaurao Shankar Lokhande, when this man married the second woman and disowned the first one. But when the first wife, that is the legal partner, came forward that he has already duped her, the second wife also says that she was married to this lady. So what actually happens is this man cunningly dupes the first woman also and also dupes the second woman. Then what happens? Who are entitled to what? The first woman, as we know, because she comes on the definition of wife as per section 125 of the CRPC, she's entitled to everything. And what happens to the second woman? If she doesn't fit it into that definition of wife, she can neither claim maintenance, nor she can claim alimony, nor succession rights, etc., etc. What happens if she conceives and a child is born? Is that child from such a relationship which is not legalized in India? Can he or she has a claim? So all these questions come in mind. And prior to 2010, that is before the Khushbu case, second relationships, this type of relationship or live-in relationship was not accepted in India. And therefore, the second partner of such a relationship would not get into it. But the recent trend you will find of the Supreme Court where such a woman has been duped, a Supreme Court is giving maintenance and alimony, at least if the woman is not aware of the first marriage. Now, in law, we know there's a word known as bigamy, Pigamy. So, if the man has gone into the second wife, second relationship, and if he proves before the court of law, as it happened in Bhavra Shankar's case or Yamuna Bai's case, that second marriage was no marriage. He did not solemnize the marriage as per Section 5, read with Section 7 of the Hindu Marriage Act. Then second marriage, he cannot be punished for bigamy, because to punish a bigamy, that second marriage should also be properly solemnized, so that it can be proved that he had done the second marriage. But if he had not performed the second marriage as per law, it means you cannot hook him even under the punishment of bigamy. So that man gets away from this punishment. The man shrugs his shoulders from giving alimony, and the man disowns the wife and has a royal good life. Now, let us then understand the legal status of live-in relationship, and in reference to that, let us understand how the judicial trend was in live-in relationship. Now, for the first time in 2010, it was only that famous case of S. Khushbu versus Kanyamal. Khushbu she was a very famous actress of South India. It is in this case that live-in relationship was categorized as a domestic relationship. And why it was categorized? Because Khushbu for a long time had a relationship with Kanyamal. So the Supreme Court brought the woman under domestic relationship and tried to give the woman a protection under the Domestic Violence Act of 2005. And the Supreme Court held, Honorable Court held, that live-in relationship comes within the ambit of right to life enshrined under Article 21 of the Constitution of India, and held that live-in relationship is permissible. So the first time the judicial trend in India is they are recognizing this relationship. They say it is permissible, and they say it is an act of two adults living together. So both are consenting with each other to live with each other, and therefore it cannot be considered to be illegal or unlawful. It may be immoral for the society, but not illegal or unlawful, because such a relationship is even today is not accepted in India. Because for us, marriage once done is done forever until and unless the partners go for divorce or one of the partners die. Otherwise, we try as much as possible to have the sanctity of marriage, even in the present day society. So the court said that it is not illegal, nor unlawful to have of such a relationship. And in a developing area, it became again a controversy to the type of live-in relationship that are recognized. In the second case, that is the Supreme Court in Indra Sharma versus V.K.V. Sharma, it is a 2013 case. It categorized live-in relationship into two. One is domestic cohabitation, that is living under the same roof and cohabiting between two unmarried individuals. But somehow they establish a domestic cohabitation, a domestic relationship. And the second is between a married man and an unmarried individual, or two married individuals. So the Supreme Court only recognized the former. What is the former? Domestic cohabitation between two unmarried individuals, and not the latter ones. That is domestic relationship between a married and an unmarried woman, or between two married partners. Supreme Court did not go into this. Then we come to the conflicting views of the several high courts. The high courts of Bombay, Allahabad, and Rajasthan repeatedly refused to give protection to such live-in couples. And they cited the reason. What was the reason? They say live-in relationship between a married and an unmarried person is illegal. And the same thing is reiterated in the Bhaura Shankar's case, where Bhaura Shankar already had the first wife. He was already married, having a first wife, and then went with the second woman. So the Bombay High Court, the Allahabad High Court, and Rajasthan High Court refused to give protection in such a relationship. The Punjab and Haryana High Court went a step further and referred these relationships as unacceptable, claiming that they destroyed the country's social fabric. Now, marriage itself is an institution. It is not only a social institution, it is a legal institution. So once we are breaking away from such an institution, the courts are saying it disturbs the social fabric. And the Delhi High Court, taking a contrary stand, adopted a wider approach. And what did the Delhi High Court say? It upholded the rights of a female living partner, irrespective of the marital status of both the individual. So whether the partner, the woman is married or unmarried, doesn't make any difference. The Delhi High Court gave protection to such a in such a relationship. Now, live-in relationship, the nature of live-in relationship has been discussed or defined in Section 2F of the Domestic Violence Act, which defines a domestic relationship as a relationship in the nature of marriage between two people, that is two adults, living in a shared household. So, you have to yardstick to bring such a relationship under the definition of Section 2F of the DV Act. One is, it must be a domestic relationship. That means they stay under the same roof, or the definition should come under shared household, means staying under the same roof, under the same flat, or under the same house. And therefore, if it involves a married person that fall within the four corners of domestic relationship under the DV Act, then such a partner is entitled to maintenance. Now, this view was endorsed. It got a judicial endorsement by the Chennai High Court, that is the Madras High Court, in the case of Malar Kodi versus the Chief Internal Audit Officer. It's a very late case of 2021, wherein a wide interpretation of this Section 2F was acknowledged by the court. And the court gave a broad, interpretation of its scope to encompass relationship of the aforementioned category. Here the court said live-in relationship as a law is understood currently and was conceptualized during the adultery regime. There's another, this can substitute the word adultery. Adultery is having adulterous relationship. That was what has been defined in or given a concept in the Hindu Marriage Act, or even in the Christian Act, or even under any other personal law. But this live-in relationship is actually has been from the word adultery. And in Joseph Shine versus Union of India, though adultery has been given a criminal statute, it has actually later given the concept, or given a live-in relationship which has to be recognized under the Domestic Violence Act. Secondly, a strong case has a relationship between a married person and an unmarried person that does not fall within the penal scope of bigamy. That is Section 494 of the Indian Penal Code. Now, the bigamy, this section, this provision explicitly is clear that it means second marriage during the lifetime of the husband or the wife that can attract criminality. Nowhere does the section say that a relationship which is in the nature of marriage will be considered as an implicit marriage under the personal law, and therefore can bigamy, where the woman, whether married or not, is in a domestic relationship for a wife or female living partner from violence. If she's constantly in violence in such a domestic relationship with a man, the focus is you can bring the case under the Domestic Violence Act, seeking an inquiry into the tangible harm that has been caused to the woman, in which in other way the Domestic Violence Act is trying to give protection to the woman. Unfortunately, this was denied by the Bombay High Court, the Allahabad High Court, the Rajasthan High Court, and the Punjab High Court, which denied such a victim on moral grounds, and said that because it does not have the sanctity of marriage, she cannot claim anything. But under Section 2F of the Domestic Violence Act, it has been recognized. So we can say is that Domestic Violence Act, that is the position of female in partner in Domestic Violence Act, has actually to prove 2 points. It must establish a domestic relationship somewhat akin to marriage or in the nature of marriage, and 2, both the partners must have a shared household. Then only Section 2F gets attracted, and then only such a relationship can be considered within the ambit of the Domestic Violence Act of 2005. The National Commission for Women also recommended the Ministry of Child Development to make and suggested that such living partners must also come within the ambit of Section 125 of the CRPC, because Section 125 of the CRPC has defined the word wife, which also includes a divorced wife. But the CRPC does not include live-in such partners of live-in relationship. So that I feel strongly that needs an amendment. Secondly, if you go with the ruling of the California Court of the US, it's a foreign judgment which invokes the doctrine of palimony, that is where the deserted woman can seek maintenance. The 4 conditions in this case was a live-in couple must hold themselves out in the society as being akin to spouses. I mean, they must behave like spouses. Whereas in India, it is live-in relationship must have a long relationship. It is not that partners coming in, staying for 6 months, going out of it, then can claim alimony or palimony. No such thing. It must be a partnership for a long of 10 years, 15 years, and the society must recognize such partners as spouses. 2, they must be of legal age to marry. So at least they must be above 18 and they must be unmarried or to be otherwise qualified to enter into a legal marriage. So these are some of the yardsticks that has been set up for live-in partners in live-in relationship. Again, in Varsha Kapoor versus Union of India, the Delhi High Court held. Now, what are the protection you can give in if such a case comes to you? The Delhi High Court held that female in live-in relationship in the nature of marriage has the right to file complaint not only against the male partner but also against his relatives. Though the Hindu Marriage Act or the 125 of CRPC till today have not recognized partners of live-in relationship except for the Domestic Violence Act. Another case you can look into is D. Veluswamy versus D. Patchayamal, which held that the relationship has to be in the nature of marriage under the Domestic Violence Act to fit into the criteria of the partners of live-in relationship. So this is what I had to spell about live-in relationship, somewhat to give an idea about this contemporary issue, live-in relationship, though it qualifies to some extent under the Domestic Violence Act only to give protection to the battered partner, to the victim of these partners, but otherwise it has still not given a legal sanctity as well. Now, let us now move into what do we understand by this word surrogacy, or what is the new concept of surrogacy in India. Now, as per the latest development of surrogacy, on 26th February 2020, that is last year, the Surrogacy Regulation Bill 2020 that allowed any willing woman to surrogate. Now, what is surrogacy? Can anybody say what is surrogacy? Tania, Ayushi, I see you here in my lecture. Vijendra Singh, can you tell me what do you understand by the word surrogacy?
Carrying
Manish?
others' child in one's womb.
Yeah. So actually, it is the lending of the womb. The woman is lending her womb to become a surrogate mother, but the moment she delivers the baby, she has got no legal right on it. Right? This is what we understand by surrogacy. And nowadays, it has been given, it's lot in nowadays a talk. Shah Rukh Khan got the third child through surrogacy. And there are many celebrities I was seeing. That Bollywood director, very known director, he also got Tushar Kapoor, again got from surrogacy. The queen of those TV serials, Ekta Kapoor, she also became a mother through surrogacy. So surrogacy, is being now taken as a substitution also for marriage. People don't want to marry, but want to become a parent. Very good. A fundamental right cannot stop from doing, because we are all individuals, we are adult. So lot of change is coming in the concept of marriage, which keeps the whole partners together, and that marriage itself, both the partners have to be tolerant, even though they're fed off from such partnership. Both the partners have to stick with each other under the common household. Both the partners are still afraid of seeking divorce, because what will the society think? So to get away from all this, those who can afford money, those who are financially stable, they go for becoming surrogate mother or surrogate parent. Now, an important development that took place on 26 February 2020, which approved the new surrogacy bill, which allowed willing women to be a surrogate. But the bill took a back seat in 2019, in 2020, due to COVID-19 pandemic. But it is again expected to be introduced in 2021 in the lower house of the parliament, maybe in the upcoming sessions. Now, this bill is a significant improvement to the surrogacy of the regulation bill of 2019, which continues to adopt a need-based approach rather than a right-based approach. Can you tell me what is the difference between right-based approach and need-based approach? Any of you? What do you understand by need-based approach? Tanya, Rohit, you should interact. It's no harm if we come out with wrong notions. What is there? Law is a matter of interpretation. Kashish, Radhika, what do you understand by
Ma'am,
need-based approach? Yes,
may I?
please. Yes, sure, beta.
Ma'am, need-based means, ma'am, what is needed? If you need a child through surrogacy, then it is need-based, and if government gives you right, so you have a right. It is up to you. You can use it or not.
So the 2019, it adopted a need-based approach rather than a right-based approach. It did not give the autonomy to the woman who is a surrogate mother, who deserves that. See, need-based approach can be both ways. The woman who's not financially stable, that's why she wants to become a surrogate mother. Because she is poverty-stricken, she does not have ample money to run her household, therefore she is lending the woman. But if you look from the other side, parents who are childless, they also want to be parents through surrogacy. Let's say the wife has some problem, medical issues, but she wants to become a parent. Her husband wants to become a father. It is also a need-based approach. A right-based approach is I, as a woman, has a right to become a surrogate mother. So these are some of the points that are missing, that was not taken in 2019, which was changed in 2020 and was placed before the parliament, but meantime, because of the pandemic, it did not see the light of the day. So the debate still has a conflicting interest in different stakeholders. On the one hand, it is the state duty to prevent exploitation of such women, of such surrogate mothers, and also to protect the interest of the newborn babies. On the other hand, there's a right of the woman to make her own reproductive choices and the right of the person to parenthood. So India is actually struggling to find a balance between these conflicting interests. Now, commercial, and in reference to this, you can read the Baby Maji Yamada case, Baby Maji Yamada versus Union of India, where the Japanese couple who had come to India wanted to adopt the child, went through the process of surrogacy, but in between, the Japanese wife had a divorce, but the Japanese father wanted to take the child because the surrogate mother had already given birth to the child. And it is here the legal problem started coming up. The Japanese government does not recognize children through surrogacy because they consider it to be an illegal child. So the baby could not get passport from the Japanese government. Whereas the baby who was under the care of some good friend of this Japanese couple in Rajasthan, and the baby's grandmother, that is the surrogate's parents, I mean, not the surrogate parents, the one who comes, the Japanese father who wants to take the child, the Japanese grandmother who came to India, wanted to adopt the child. The adoption process was very lengthy. So a battle was going on, where will the child be, whom the child to be given. So I'm sure most of you who have not read this case, Baby Maji Yamada versus Union of India, please read this case as to how the baby, these parents who want to come, these foreign couples who want to come, take the child from India, how they face the problem. So consequently, from 2008 to 2014, there has been a continuous attempt to pass some legislation regarding surrogacy. And the activist lawyer Jayashree Ward also moved to the Supreme Court, highlighting the pitfalls of the surrogacy industry. In fact, surrogacy is now a boon in India. It is one of the third industry which is actually booming in Goa, in Rajasthan, where foreign couples or couples from rich families, they come and they want to have a child through surrogacy. So it's actually a boon industry in India. So this advocate, she filed a petition, shaped the public opinion, created a significant pressure to the government to pass the surrogacy regulation bill of 2016 that was introduced in the Lok Sabha but could not be passed in the standing committee of the Rajya Sabha. And again, an exercise has been culminated in the 102 report in 2017, which again suggests some progressive changes in the 2016 bill. So now what was the suggestive measure? If you have some patience, I will quickly glance through. The committee recommends deleting the clause which defines infertility. That it says only those couples who are infertile can become parents. So it has deleted that cause infertility. And secondly, the waiting period of 5 years before the issuance of that infertility certificate, thereby making access to surrogacy easier. It also recommended deleting the clause which not only allowed for close relatives, there is a close relatives that close relations or friends can also become surrogates. So it ignores the ground reality of most Indian families where women have little decision making, making it authority to the men only who wants to have a child through surrogacy. So women, either way, woman, the wife of such infertile partners, or the woman who is bearing the child, that is surrogate mothers, they are somewhat coerced into providing reproductive labor. So the committee has corrected some of the flaws of the 2019 bill, but it retains other clauses, and it maintains a need-based approach towards assessing surrogacy instead of advancing on the right-based approach. And this development comes among the growing trend of the Supreme Court that broadens the liberty under Article 21 to include the right to make reproductive choices. By banning commercial surrogacy, the bill does not, of course, takes into account the intersectional aspect of the law that has an impact on the woman's right. They expect that the woman should go through the physical and emotional toils of surrogacy free of cost and compassion. So the proposed bill denies it also denies the bill to the LGBT rights, does not speak where the LGBT or the gay couples or the single parents can go through the essential ambits. So they where there is biologically impossible for the person to have a child in any or the other way. It does not consider any medical conditions, because sometimes women may not be medically fit to bear the child. So, and they may be infertile, where pregnancy is also at risk. So all this has not been considered in the 2019 bill, and therefore there still remains a loophole for in the surrogacy bill. So I think these aspects must be looked into. First of all, in live-in relationship, other than alimony maintenance, what more protection can be given to women in live-in partners, or in surrogacy, how much the woman who is surrogate mother, she is entitled to the benefit, because the money actually goes to the clinic or it goes to the middleman, and this poor woman who actually bears this child for 9 months, who is emotionally destroyed after bearing the child, I mean, she should be given more benefit. So these aspects are not well taken, and certainly a legislation should be more progressive in this matter. So I think that's all for today. I can only cover up 2 topics, though I tried to cover up. We have got a lot of discussions, lot of things to discuss, but I think the topic has been jumbled up. Too many topics has been jumbled up, which again can be discussed on some other day. And thank you very much for your patient listen. Thank you.
Thank you very much, ma'am. You're truly an epitome of knowledge. It was extremely valuable to be a part of this session. Ma'am, with your permission, do I ask the students to put up their questions?
Yes, sure. We'll
So,
take one
whosoever,
question, not more. Okay, Manisha?
okay, ma'am, okay. So, whosoever is having any queries or question can raise their hand or turn on their speakers and speak.
You can screen the questions if you feel like, because yes. Yes,
Excuse me, ma'am.
yes.
Ma'am, my first question, like you talked about loopholes in surrogacy, which is banning for single parents and homosexuals. This clearly intends the discrimination against these people. So how this loophole is going to be covered?
Yeah,
what
it is
approach
for the
should
legislation to think, because LGBT partners or gay partners or lesbian partners, they also want to become parents. So we have to look which country or which, I mean, we have to be more progressive towards them, more human towards them. So they have to include the definition portion, how to cover up partners of such live-in relationship, gay partners or lesbian partners, because now LGBT are getting recognized. They have still not got recognition in the Hindu Marriage Act. It only says two partners who have to be Hindus. What about the marriage of LGBT partners? So those things, our society is not progressive that way. So it is the legislation, the legislators to think about it. It is not my job or the judiciary's job. It is the people who are sitting in the parliament. They have to be more progressive minded.
Ma'am, it's liberal thinking, ma'am. It for that to become, our India is not having that liberal thinking that our legislators are going to change it very soon. Because India is not having a liberal thinking. You see, Hindu Marriage Act. It's not a liberal law, but I think like in Western countries, you see, very liberal laws are there, but not in India. The case is very different here. So as a citizen, not as a law student or not as a judiciary person, like involving ethics and all other things, seeing from every perspective, we need to come. We at the end of the day, we can't rely only on legislature that they are going to do this, because root cause
Judiciary,
problem is within the
always the
within the
judiciary is
nation.
our job to point it out. Well, what are you doing sitting in the parliament then? Only to make lectures. You have to have a knowledge of law. You must have the knowledge of the society. Otherwise, you are not a good parliamentarian. Simple. It took so many years to give women the right to succession, to right to succeed in the property. What will these parliamentarians do to give the rights to the women and to the LGBT partners? We are all aware that India is not liberal, but somehow we have to make a breaking point. The ice needs to break. Can't sit back and say that India is not liberal. Either you file a case, PIL case, as to how this woman, this lady activist fought for surrogacy. One has to fight the way through. And everywhere job is segmented. If you're not a good parliamentarian, if you do not think good and welfare for the society, better step down.
Ma'am,
Thank
we
you.
have one more last question from Ayush. Can we take up that?
Yes, yes, please.
Ayush?
Very good afternoon, ma'am.
Afternoon.
Uh, Ma'am, you have talked about living relationships, and I think we do not have any, specific legislations regarding to that. So, ma'am, I want to ask you that can the implementation of uniform civil code could solve this problems like all the consenting living adults come under the ambit of this one law?
So, relationship is entirely a different concept. It doesn't fall within the category of personal laws. What is personal laws? Where my religion, if I am a Hindu, then only the personal law comes into play. Live-in relationship is simply staying together. Together, it's more a matter of convenience than a matter of necessity. It is other alternative to marriage, as I told you in the beginning of the lecture. If I don't want to marry a partner, but I like a partner and both are consenting parties, we go into live-in relationship. But live-in relationship only is recognized if the relationship is more beyond 5 years, 10 years, 15 years, where society is accepting these partners as live-in partners. It's more or less like husband and wife.
Okay, ma'am. Okay, thank you so
Not
much,
just
ma'am.
coming in, having fun and going out and asking for alimony. Such relationship is not accepted. It's more immoral. Not only in India, it's also in Western countries. You have so many unwed mothers in Western countries. But the difference is, in Western countries, such mothers are meant by the society, maintained by that country. In India, such mothers are looked down and not maintained by the country. That's the difference between Indian perspective and perspective in other countries.
Thank
Okay,
you
ma'am.
very
Thank
much,
you so
ma'am,
much.
for clearing our doubts with such ease and fineness. Although this questionnaire can go for long, but due to restrictions of time, we must conclude the session here. I thank our honorable guest speaker, Dr. Sangita, for sparing her precious time and hope your words of value are a life changer for many. Thank you so much, ma'am, and who all are present here. Have a nice
Thank-
day. Stay safe.
And thank you for giving me an opportunity to interact with your students. Thank you
Thank you
very
so
much.
much, ma'am. Thank you. The session was really interactive. I think the students are still waiting to ask you more questions, but
We
because
have
of paucity of time, we can.
with the next session, it's a jumble of topics. Topics you have made it in this session without consulting me. In family law, you cannot jumble so many topics together and try to finish it in one session. I'm
Yes, sir.
sorry.
Yes, ma'am. Surely, we will take care of it next time. And thank you for cooperating with us. And thank you for, in spite of the internet glitches and everything, thank you for being there. Thank you so much, ma'am. Thank you.
God bless. Happy that.
Thank you, ma'am. एक बार एक नहीं. All students need to fill the feedback form. I think I have shared it with their class coordinators also, since you were not able to access the chat box. All need to fill the feedback form. Then only you'll be able to access your participation certificates, right? And thank you for joining in. I hope you all enjoyed. Thank you all. All can leave now, I think.